Welcome back. You're watching All Angles. The Constitutional Court has dismissed an appeal to have foreign nationals admitted as legal practitioners in South Africa. You'll remember that a group of foreign nationals filed an application to challenge the September ruling delivered by the Free State High Court. The court had declared a section of the Legal Practice Act unconstitutional and invalid. To help us unpack this, we speak now to constitutional law expert Professor Pierre de Vos from the University of Cape Town. A very good morning to you, or afternoon rather, Professor de Vos. For those of us who weren't abreast with the case, perhaps give us the nub of the issue and the reason that the applicants went to court initially.
So the legislation says that if you can only be admitted as a legal practitioner if you're a South African citizen or a permanent resident. So applicants who has a law degree, went to South African universities, had work permits to work in South Africa and were legally here, challenged this, saying that it was unfair discrimination and that it was also irrational because it's too broad. It doesn't make any exception for people, say, if you're married to a South African citizen, if you're a refugee, when international law you have in South African law you have a right to work. But the court obviously dismissed these arguments and said that it was discrimination, but the discrimination was justified for various reasons.
What are those various reasons, Professor de Vos? Because when you look at the merits of this case, one wonders, if I studied in South Africa and I've put forward all the arguments that you've just mentioned, surely there has to be some kind of leeway. So when we talk about the discrimination and other reasons, what would those reasons be?
Well, I agree with you. I don't think the court's reasoning is very persuasive. But the court said, firstly, that in terms of the section 22 of the Constitution, a different section, the right to choose your profession is limited to citizens only. Other rights, like the right not to be discriminated against, is for everybody. And so they said, well, the Constitution itself makes the distinction. And they also said it doesn't really harm those people who have work permits and are legally here and may have made a life here by marrying somebody here, because they can always do another job that doesn't require them to be admitted as a legal professional. Of course, that other job might not be of the same quality and so on. Whether they will get a job, of course, is another matter, because it's not so easy to get a job as a foreign national, whether documented, undocumented, permanent, or whatever else. At least the court rejected the argument by the state, which I think is explicitly homophobic, to say this law is necessary because there will be corruption or there will be shenanigans around this, assuming or suggesting that foreign nationals are per se dishonest or whatever the case might be. It makes no sense, because most of these applicants got their law degree at South African universities. So whether the judgment is persuasive is another matter. It is important, though, to make clear that this is not about a right of foreign nationals that are either documented or undocumented to work in South Africa. It was only about people who already have the right to work, and which the Home Affairs has either never responded to the applications for permanent residence or have rejected these for various reasons.
I mean, you said something about them being able to get other work. And I was thinking, as you were saying that, Prof, that in itself is a little bit unconstitutional, wouldn't you say, in that my freedom to choose what it is I want to practice is being limited because of a law made or defended by arguments, as you've just mentioned, aren't all that strong.
Well, that is not necessarily true, because, as I've said, the specific right that guarantees for you the right to choose your profession is limited to citizens only. Most of the rights in the Bill of Rights apply to everybody. Everybody enjoys it, but only citizens have this right. But the argument that this is unfair discrimination, not only because the category of people are extremely vulnerable. We see the xenophobic violence unfolding all over South Africa, the hatred. Serious offices had to be closed because of xenophobia. So they're vulnerable, and the impact on them could therefore for this reason, but also because they might not be able to find another kind of job for which they don't have qualifications, might actually be quite devastating.
Going forward, and just based on the case that we've just unpacked here, Prof, do you think that there will be scope for more people to come forward and continue to challenge, and perhaps we might see a different outcome as more and more people come out to challenge the specifics of this kind of case?
Yeah, the Constitutional Court has not been very vigorous in protecting the rights of foreign nationals in South Africa. There's been other cases dealing with employment in the security industry and so on, where the court didn't really make a very progressive judgment. So what is surprising about this case is that there was no exception provided for to give any leeway even to the Department of Home Affairs, which we know would not have responded or would have rejected the application, but still. And whether there is scope for other challenges, we will have to see. It will be difficult, given this case and 2 or 3 previous cases that came down from the Supreme Court of Appeal and the Constitutional Court.
Professor Pierre de Vos, thank you very much for elaborating on this particular court case and the judgment thereof. That is Professor Pierre de Vos there joining us to speak about the foreign nationals who went to court to appeal a decision made by the Free State High Court about them practicing law in South Africa.